Hello, everyone. Welcome to another episode. Today we have Tamany Bentz. She's an international IPO lawyer. She worked also for the government previously in the district court. And Tamany, welcome to the episode. How are you today?
Thank you, Julio. I'm doing great. Really excited to be here.
Thank you so much. So, Tamany, for anyone that is hearing us or hears in the future, tell us a bit about who is Tamany. I mean, how would you describe yourself? Who is Tamany and your journey until today?
So I am an attorney. I've been practicing law for over 20 years, the mother of two kids, and somebody who is an avid reader in her free time. That's how I would explain myself.
Interesting, interesting. So, tell us a bit about your interest in law. I mean, what was it? Something already from childhood? Did it happen sometime when you were studying? How will all this go?
Yeah, it happened very organically for me. I have a science background. I got a science degree in college in the United States and initially intended to go be a research scientist. At the time, nobody really knew, like if you had talked to people about what I wanted to do, they wouldn't have known what it was. But today I can say I wanted to be Dr. Fauci. Basically, when I was younger, that's what I wanted to do. I wanted to do public health and I wanted to be him. Now, though, when I started in undergrad, I did an internship actually at the American Association for the Advancement of Science in the 90s. And my job when I was there was to write a pamphlet that would educate Congress people on stem cells. At the
Okay.
time, stem cells were very controversial because they came from human embryos. And there was a lot of discussion on Capitol Hill in the United States about banning them. And scientists were obviously concerned about this idea that this foundational discovery would get banned and we wouldn't get any chance to see what would happen to it. So my job was to write an educational pamphlet that was just the facts, ma'am, no politics, the science behind stem cells. And then
Right.
I went and presented that to people at Capitol Hill to try to educate them on the science. So at least if they were going to ban it, they would have some understanding of what it was that they were banning and not be
Right.
making decisions based on rumors.
Right.
I loved that job. And I was working with lawyers in that job. And so that is the moment when I said, I'm going to go to law school. This is what I'm going to do. I'm going to educate politicians on science. And I'm going to get a law degree to do it. So I went to law school. I went to the University of Pennsylvania.
Right.
I got a joint degree there. So I have a master's from the medical school in bioethics and a
Okay.
law degree. And while I was in law school, I realized I was really good at a class called civil procedure. Anybody who's been to law school in the United States is going to roll their eyes and go, nobody loves that class. Everybody hates that class. It's the worst one. But I loved it. And a good friend of mine said, you can't love civil procedure this much and not go be a litigator.
Right.
So you should at least try to be a litigator. And so I spent one summer working at a federal court in Arizona.
Yeah.
And then after I graduated, I went and worked for the federal court in Delaware. And that's sort of how I got into a traditional law career.
How was your experience when working in court? I mean, coming from study directly to reality. I mean, what was your feeling about it? I mean, tell us about it. Yeah.
So the thing that most people don't understand about Delaware is in the United States, Delaware gets litigation between very big companies because
Right.
most companies in the United States are headquartered or they're registered in Delaware. They might not actually have headquarters there, but that's where they're registered because corporate laws are so favorable to them in Delaware. So most of the litigation we had in federal court was between big companies, high stakes litigation. They hired, because they had the money to, they hired some of the best attorneys in the country. So the really cool thing was leaving law school to the real world and getting to watch some of the best attorneys in the country
Right.
do their thing on a daily basis. And I had what we call a co-clerk, which is kind of like a partner. We divvy up work working for the court. And my co-clerk and I realized something really quick. These people are really good, but they're not always really good. Even they mess up. And so it kind of gave you a look into the real world of, okay,
Yeah,
you can be really good and you're still never going to be perfect. And I think that
absolutely.
practicing law was a really great thing to learn early on. Even the best in this
Yeah,
business are not
yeah,
perfect all the time.
yeah. I always say it's not possible to be perfect. It can be almost perfect, but in the end, we all human beings, and there's always gaps. Always.
Yeah.
Despite that, the greatest people everywhere, they always say, we can do anything. Yeah, but I mean, you cannot literally do it 100% perfectly. That's not possible. It doesn't matter who you are. And this is where there's big differentiality. Of course, you also get people who actually have that type of character, and some people at that level who don't have it. So when it comes to that, it's very hard to talk to, and that goes everywhere. I would say not just in law, but in any sector, it actually happens. But what I always say is to get the experience and to get that proper knowledge, you face everything. And I always say you need to get in on the rain to get wet, to know how does it feel like, what you need to do, how you should do to not get wet. But you need to pass through those. And when you pass through those, you don't actually know it yet what's going to be the resolution. And this is where people always say, "No, no, I know exactly what to do." You don't, you don't. Yeah, exactly, So,
We have a saying for that in the United States. I played softball in high school, which is like baseball, but for girls. And my coach used to say to us, because you need to lead off the first base plate, right? Every time, if you're on first base and there's pitching going on, you need to lead off so that you're closer to second base. And
yeah,
our coach used to say to us, if you don't get thrown out at first base sometimes, you're not leading off far enough.
yeah,
So
yeah,
basically, and so I actually say that to my kids now. I say, if you're not going to get thrown out at first base, you're not leading off the bag far enough. You really do have to get out there and push yourself.
yeah, of course, because that's the way you need to understand what are the things you need to improve,
Mhm.
what actually it needs to be improved in order to to get to that certain level that you also want to achieve. Because I mean, you can have auto evaluation yourself, but you won't have everything. So you need other people to tell you what are your gaps, what are the improvements you need to do, and where to do them, and how to do them. So in the end, it has to be always the teamwork. It's not about just one single person out there trying to do whatever. I mean, you can try, you can say you're doing it, but it doesn't really work that way. I mean, you need other people to be around you likewise and minded wise, of course,
Mhm.
to get that improvement that you need to get there, for your career, for your improvement, for people to know you, and always be humble. That's
Mhm.
the thing that most people sometimes miss out, especially at this level, the level we're talking about. People
Yep.
miss out not being humble. You need to, and there's nothing wrong with it. And he always makes you that a better person. Doesn't matter what people say. It really does. And that's what I usually say to everyone. It will help you in your personal life, and it will
Mhm.
help you in your professional life all the time, because you want to get always a gap in some point of your life that you need some type of advice that you don't know how to break through, and you need to follow through. So tell us a bit about the experience that you had during some cases, whatever you can talk about, of course.
Well, I've in the 20 years I've been working, I've worked on a lot of different kinds of cases. Everything from when I worked for in Delaware, I was the clerk on what we called the stent wars on cardiac stents. So started out my career with a lot of knowledge on stents. And Then the first case I had after I left Delaware and I went to a law firm was about smallpox vaccines and stockpiling smallpox vaccines, which I probably too long a story to walk everybody through the history of smallpox vaccines, but it actually is worth reading. Google it and read about the history of it, because it actually is a pretty fascinating lesson in public health and how governments can work together and to achieve great things in public health. So that was a fun case, if nothing else, just to learn the history of that story. Then I moved to Los Angeles, and I started working more in media. And have worked with some A-list celebrities on trademark cases dealing with merch that they sold, and actually represented, this is all public knowledge, but I represented Snoop Dogg in a copyright case over a movie that he co-produced, which was also an interesting case, and kind of built this reputation for being somebody that works in popular media, but also digital media specifically. So the case I represented Snoop on, he was streaming the movie on a platform called Trapflix, and that was part of that case. I actually was counsel in the first case that I am aware of to litigate copyrights over viral videos on social media. So in that case, I represented a company that owns a large library of viral videos. They go license them or buy them from the people who create them. And the entire case was about whether somebody could use their videos for a clip show on YouTube. So that was, maybe the first time a jury's ever spent days watching, no joke, watching viral videos, just one after the other, after the other.
Amazing.
There was no other way to show them whether whether the uses was similar, whether it was fair use. We had to show them the videos. So I think it was like a day and a half. The plaintiff would get up and play his video, we would get up and play our video, and it would just go back and forth. Maybe the most entertaining jury trial, at least in the history of California, probably. So that was really where I kind of built a brand for doing things in digital media and social media. And since then have been working with brands and startups and how they really monetize their IP through social media and also protect it.
What advices would you give to companies and people out there professionally that are not doing the right thing, let's just say, in your point of view of expertise, and what could be done? And if all organisms in government actually work in compliance to make things easier or are very hard to do according to current regulations. So tell us a bit about your advice.
So we'll start with, a lot of companies are doing what they're doing, not because they know it's wrong, but because they didn't talk to anybody with that expertise. Because they were either told it was too expensive or they just think it's too expensive. So what I would say to those companies is you should do a few critical things, which is you should talk to somebody about whether you have the registered intellectual property rights that you should have. There was a study that was done 1.5 years ago. It came out that looked at European startups in particular, and found that even just a registered trademark had a large effect on the value of that company when it came to raising funds to keep the company going. Patents had an even more heavy effect on the value of the company. So there is hard data to say that actually registering your IP has a return on that investment. So the number one thing that companies should be doing is just talk to somebody. Make sure you have what you need to have, and make sure that whatever you have is focused on what the value proposition of your company is. What is it that's your secret sauce? What is it that's your value proposition out to customers, to clients out in the world? Build your IP around that value proposition, because then it's going to return on your investment. Getting IP just to get it, not going to return on your investment, but focusing on that value proposition will.
Right.
Compliance, I mean, there are, depending on what countries people operate in, I mean, right now in the United States, compliance issues are changing, I think, daily, maybe hourly. So if you are in a world where you have regulatory compliance, then you definitely should be talking to an attorney on a regular basis. Right now, you know, I have a lot of clients who are spending a lot of time on the phone with their attorneys for importing goods into the United States, right?
Yeah.
Just trying to figure out what their options are to legally and inexpensively get goods out of China into the United States, or right now pretty much out of any country into the United States. So that is something that is changing very quickly here. And so that's, if you are importing goods in and out of any country or that and around the United States, then yeah, I think you should be talking to a lawyer regularly.
Would you think, apart, of course, from the mess that the government did with the tariffs, would you think, as your expertise regarding this, and according to the compliance of IPO, of course, is there many things that could be changed to make it easier? Putting out the tariffs on the side, just from the legal and perspective point of view, is the system really compliant and easy to work to get a trademark registered, and it's like straightforward? Or if not, what steps would you think that the government should change to make it more appliant to anyone and companies to go for it?
So I actually think when it comes to trademarks in the United States, it's pretty straightforward. They actually just revamped their system online. So each step has kind of like a educational component for people to read about what it is exactly they're doing. The idea was not directed towards people like me, like the attorneys that are filing trademarks, but I think it was intended to try to get better output from people who file trademarks on their own without an attorney.
Right.
But the process is pretty straightforward, and I think actually, given the volume that the trademark office handles, or even the patent office handles, it runs pretty good. I mean, you could nitpick certain issues, but I think it runs pretty good. I am watching it to see what happens over the next 9 to 12 months, because the USPTO is on a hiring freeze. So I've actually talked to some people who had offers of employment there, and their offers were frozen, so they haven't even started work. And then the USPTO is actually and has been a remote work agency for 25 years, which means the people who work at the USPTO live all over the United States. They don't necessarily live next to one of the federal USPTO offices, and there aren't that many of them across the country. So if they had to go into the office, the vast majority of them would have to move, and they would all become centralized around 4 or 5 cities in the United States.
Right.
Nonetheless, they, initially when President Trump took office, many of the government agencies were told that they were going to have to stop remote work and come into the office, and the USPTO was included in that. So I'm curious to see if things slow down with the USPTO because of some of these developments, if they become overworked. In my opinion, there are certain periods in the history of the United States where the Copyright Office and the USPTO have issued registrations on things that should not be registered.
Right.
So to me, there are certain times in the history of the country where it might be a good time to try to push something through and see if you could get it through. I think we may be coming up on one of those times because I think they may be understaffed and overworked here pretty quick. So I'm watching that and to see kind of what changes we see out of what's happening and what is issuing from these offices. But generally speaking, the system's pretty solid, I think.
Right, right, right. And according for people who want to go internationally, would you think going internationally abroad, bring a trademark on? Is it very complex procedure? What sort of length of implementing it we're looking at, and how complex is it? Because in each country has their own laws and regulations. So, just in resume high level opinion as expert on that, tell us a bit about your opinion on that.
So, for the most countries are in something called the Madrid, and there's a Madrid protocol, which allows you to file trademarks pretty seamlessly across a number of countries. So for the most part, filing a trademark in other countries is not that onerous. I think for foreign companies coming into the United States through the Madrid protocol, they have to have counsel. I think that's probably the one wrinkle that they sometimes run into, is that they need to hire a US-based lawyer to do that for them. I think Canadians can use a Canadian lawyer, but for most countries, you have to use a US-based lawyer to do it. So you see them run into that wrinkle sometimes, but for the most part, it's pretty streamlined. But what I tell companies when they think about, and I would tell this to even companies operating in other countries, not the United States, when you think about international IP rights, think about the countries where you plan to make money. Because again, registering IP just to register it isn't really that valuable for you. Registering IP that you're going to use is valuable to you. So think about realistically, which countries do you plan to go make money in? And those are the countries where you should look at getting registered IP. Patents are also somewhat streamlined because you can do a PCT approach to patents. But they are obviously much more expensive when you start to take them internationally, because each country has its own fees, its own annuity schedule, and those I have seen add up for companies really quickly. So especially when you're looking at patent protection in foreign countries, I would say look at the countries where you're going to make money.
Right. What advice would you say? Because this happened to me also. For example, if someone, let's just say, try to use your brand, not legally, of course, and without authorization in a country that is not trademark registered, and eventually, from my case, we went to legal case in court and was filed, and I won, of course, but. Is there an easier way, to do when something like this happens?
So it depends on how they were using it. So a lot of what I see is people will use it as a URL for a domain.
Yeah.
Those are actually more streamlined because you can go to an international body called ICANN if you have a registration in a country and get that domain back, or at least taken away from them in most cases if they're not making a legitimate use of it. So that can be more streamlined. If they're using it for a business, it's really going to depend on what the laws of the country where they are at are. So if that were to happen in the United States, if you didn't have a registered trademark in the United States, you would have regional rights in the United States. So then it would be a discussion of where your trademark was used in the United States and whether theirs was overlapping with that and whether you could make them stop using it in those regions.
Right.
Every country will be a little bit different in how they treat unregistered rights, but I would venture to guess that almost every country is going to take confusing consumers pretty seriously. So if the issue is them using your brand to confuse consumers into thinking that you've endorsed them or you're related to them, my guess would be that every single country has a law against that. They may call it something different. It may be couched in some different way. But I don't think a country is just going to say, oh, yeah, go ahead and mislead our people. Go for it.
Yeah, what in my case was a company in the Orient, in Asia, was using our brand and part of our information from our website in their own website and putting as an endorsement for selling the services which were not ours, and it was like it was ours. So it became serious. It became serious because they tried to make a business with a person that was physically our customer, and that's when the situation really was very, very serious. And when juridically, I mean, it went very serious, honestly. And so I just wanted to bring that up because for sure this can happen to anyone, especially in these days with the amount of things that are on the internet, or trying to confusing or trying to take advantage of a brand to sell themselves, So just want to bring that up for general information. So
yeah, I mean, most of the time it's incredibly difficult to find who's doing it these days. So for you, it wasn't hard to find who was doing it because they were actually approaching your customer to sell them the services. But sometimes what companies see is they can see somebody using their brand to sell something, but they can't figure out who's doing it.
Right. Just for general knowledge, we actually have a mechanism that inspects the whole web worldwide every day. So we get a trace back, whatever the name or the brand is somewhere, we can detect it in 24 hours. So that's how we do things.
It's smart.
So what part in your expertise, what more can you tell us about IPO? How do you start to put yourself apart from the customers we already mentioned about? And tell us a bit about all the components that has the IPO itself, because people just think IPO is just something. No, it's much more than that. So tell us a bit more in detail.
Yeah, so the best IP strategy for any company is built in layers because they cover different types of IP, cover different things. So patents are used to cover your ideas, whatever your idea is. But copyright won't cover an idea. A copyright will cover a particular expression of an idea, but not the idea itself. A trademark is going to cover however consumers recognize you, however your clients recognize you. Could be your name, could be a color, could be a scent. Sometimes it's a scent, sometimes it's a noise, sometimes it's a tagline. Whatever it is that you use to identify yourself to people is a trademark. I think those three areas are the areas that people typically think about when they think about IP. What they don't typically think about until it's becomes a problem is something like trade secrets. Like, what is it that's not a patent? It's not a trademark. It's not a copyright, but it's still information that's valuable to your company. What is that? And have you actually really built in the proper protections for it, right? Is it only disclosed to people who need to know it? Do you have NDAs in place with everybody? Do you have proper employment agreements that would control that information? I see businesses skip out on trade secret protection all the time. And then what happens is somebody uses something that they thought was theirs, and it's too late for them to protect it because they either disclosed it one time without an NDA, or they had 5 employees, early employees of the company who didn't have proper agreements in place. And once it's out, you can't really protect it anymore. I've seen companies file trade secrets in patent applications that they didn't ever really expect to issue as a patent. They just thought that they would file an application, like a provisional application, scare off some competitors, and never really pursue the patent. And then it turns out that they've blown any trade secret protection they could ever have. So trade secrets is one I think people often should be thinking about from the jump, and they're really not.
What advice would you give when there are trade secrets, which from the not like information point of view, because you can cover that. Well, NDA can be overflown sometimes because it always has some gaps. But let's just say, leaving that apart, when it's become to do commercial, it's like when you have really some part of the information is a trade secret, but is part of the commercial strategy that some of it it's to me made public. What kind of advice would you give in this situation?
Well, if you have to make the information public, either as part of your business model or part of your services, then it can't be a trade secret. So that's important to know, because it's important for you to go, okay, well, if this is important, how else am I going to protect it? What other area of IP am I going to use to protect that if it can't be a trade secret? But it's important, if you think you have a trade secret, for you to drill down on what that is, so that it doesn't accidentally get disclosed if it's tied to some piece of information that you have to disclose. Maybe you disclose, 50% of your formula,
Yeah,
but not 100% of your formula.
right.
And then the portion that you didn't disclose becomes a really valuable trade secret. I often encourage startups, when I'm working with them, to really think about it in this kind of way. Okay, what am I going to get a patent on? What am I going to get a copyright on? What am I going to get a trademark on? And what are my trade secrets? And I have them list them out. I don't have them list them out in detail, but I make them go through the effort of really thinking through, okay, I'd like for this to be a trade secret. Is it publicly disclosed? Is it publicly disclosed on the back end of my website, on the back end of my app, in the marketing material, in the, in the module that I give the client?
Yeah.
No, it's not. Okay, so this is one we know is going to be a trade secret. The benefit of that is because if the day ever comes when you think somebody has taken your confidential idea and started their own business, you are ready to go. If you know what those trade secrets are and you protected them, you are ready to go enforce them. Often companies are starting from 5 steps behind where they should be when that happens to them, because they haven't even really thought through what the trade secret is.
Right, right. Does it happen? Of course, I mean, there's all kinds of circumstances, but have you had it happen to you that some company actually made information public which was similar, because it happens, in today's days. Sometimes people even do similar products without having known that some company already has this product on or a similar brand or product already registered on the market. When this kind of clash happens, what will be your advice to this?
Well, if my client is the first to market, first diligence to make sure my client actually was first to market.
Right,
Because if my client was not first to market, I would tell them to sit tight.
right,
But first do some due diligence, see if they actually really were first to market. If
right,
they were first to market, then I'd break it down. Okay, is this a patent situation? Is it a copyright situation? Is it a trademark situation? What layers of IP do we have that we could go assert against this other company? Trade secrets is usually not the first fallback that I would have in that sort of situation, because trade secret cases are messy.
yeah,
Patent, trademark, and copyright cases aren't as messy. So if you can assert one of those 3, great. If you can't, then we start looking at some of the trade secret aspect. But for trade secrets, there should be some connection between this knockoff company
yeah,
and the original company, whether it's an employee that went between the two,
yeah,
or maybe they presented the idea to that company for funding or for manufacturing or
yeah.
something like that. There's usually some connection between the two companies if you're going to have a trade secret case.
Right, right. So, I mean, of course, when this happens, if it becomes leaked information, becomes a juridical problem also, because it was information leaked from one company to wherever
Mhm.
its employees start to work with. These cases already happened many times in
Mhm.
our history. especially in big companies. We've been seeing that happen. What phase? I mean, what juridical punishment the person who actually leaked the information would have in this case?
I would say the vast majority of the time it is a civil issue in the United States, which just means they could face some monetary payment.
Right.
There could be some court order telling them that they can't work in that industry for a period of time. Those are the kinds of consequences. There have been a few instances, though, in the United States of people who took trade secrets that would be considered in the technical nature,
Yeah.
and gone to China, for instance, and they have faced criminal consequences. But that was more because of the nature of what they took.
Right.
And to be honest, the fact that they took it to a country where the United States government thinks that they are in competition with. So, but those cases are rarer. They're not unheard of. The last few cases I have read about that have had criminal consequences have been in pharmaceuticals and in tech.
You think these cases happen? It's because of money. It's because of ideals. Why do you think that sometimes these leaks happen? And what makes a person to do them? Of course.
I think it's usually money.
Right.
I think there probably is some ideals involved in this way. I think most of the instances you have an employee, an executive working for a company, and they see an opportunity to both make more money and do it better somewhere else. So they go and they go do that same, they think they're going to do that same thing better and make more money somewhere else. And they take the information that they need to do it. That's, I think that is 9 times out of 10, the scenario. It is both things.
Right.
In many cases, that person that moved that information doesn't really recognize that they're moving trade secret information. In my opinion, they think the information belongs to them because it's the information that they worked with all those years. In the United States in particular, the line between what employees own and what the company owns isn't always clear sometimes.
Yeah. I mean, there's a lot of situations. Sometimes the creator of the idea is the actual employee, but of course, as patent likewise, the owner actually is the company. But how it's determined in that such way, and likewise, and this was happened to a person at which I know that the information was co-worked 50-50, between your employee and the company. And in the end, the breakage didn't went through well because the company wanted more and started to having retaliations with the employee, etc. So, from your point of view and advice, how would you advise the person that actually has some legal, information legitimate from this person and wants to fight a company, and likewise the opposite?
So, for both cases, what I tell everybody, I in fact just told this to my husband the other day.
Right.
You need to be clear with your employer if you think you own something, because you should assume that your employer thinks they own everything, including in some employers think they own your social media accounts. So if you think you should be really clear about what you think you own, and that should be in writing.
Yeah.
Because if you're the employee and you've made it clear that, this social media account, that even though you're using it to promote your employer, and even though you use it to talk to your employer's customers, it is still yours. If that is in writing and they tried to take it from you when you left your employment, you could fight them for that. And I'm using social media account here, but the information could really be anything. It's just social media accounts is sort of easy for people to kind of understand.
Yeah.
But if you don't have it in writing, it's a very expensive proposition for an individual to think they're going to fight a company for that. The same holds true for a company, though. If you think that you are going to make money or monetize information or social media accounts that are run by your employees and in the possession of your employees, you should have it in writing that it belongs to you.
Right.
Because then when your employee takes it, it's easy and cleaner for you to take it back. But if you don't have it in writing, it's equally as messy for the business to take it back as it is. It's just the business probably has more resources to fight the individual.
Right. So tell us a bit about what are the most significant efforts that you have daily, for example, in your line of work with your company IPO.
So a lot of what we do on a daily basis is talk to clients, talk to companies about their strategic plans for their business and how we can use all these different areas of IP to get them there. And for a lot, and I may not talk to my clients every single day, but I certainly talk to them monthly because business is always changing. Right. A new development that I have been talking to clients about that I was not expecting is that some clients are freezing their businesses right now because they cannot afford to make or import product right now, given the tariff situation in the United States. So they are freezing their business to see what happens next. Right. So I didn't expect to have conversations with clients about how to maintain their IP rights when they're not using them. But that is a thing. If you don't use your trademarks, you lose them. Now, you know, it's not immediate. It's not you freeze your business on Monday and on Tuesday you don't have trademarks, but it is a factor in a lot of what businesses, especially my clients, which are startup and emerging businesses, are dealing with right now. And what is our plan to help them keep their IP rights so that when the situation changes, and eventually it will, we don't know when, but eventually it will change, they haven't lost their brand and their rights. So that's a new wrinkle. Wasn't expecting that in 2025, but that's what we've been doing.
There's always something in the Pandora box. I mean, international, I can speak from my point of view. I mean, the tariffs was really a mess. I really would advise a lot of people in the U.S. government to relook at what's actually done with the tariffs, because they're not really helping businesses. And we're not talking about just U.S. companies. All market these days is all interconnected. All companies work internationally, most of them directly or indirectly, because not all products are produced in US and not all products are produced in Europe or Asia. So in some way, you always need to acquire a product or solution outside, and goes likewise. So with what was done, most prices become uncompetitive, so people are lost right now in the market, not knowing how they find themselves competitive again with their solution, their product, or what they want to sell. And most importantly, for the manufacturers, how they continue to manufacture the streamline of production when some of the products have increased substantially and don't know how to go up with the whole operation. So, all these factors in the U.S. government should really take a look at and rethink if they really think they're actually businesses or not. Because, the impact is being really huge, just for U.S., but also Europe, Asia, everyone. It's worldwide right now. Everyone is affected. Plus, of course, all the segments that involves into it. Uh, there's always, of course, because there's difference of tariffs, so that also difference of compliance. So
Hmm.
everything is shifting. And the old days making all the companies and citizens confused. And this is what they really think and look at with the strategy, whatever they want to achieve. This is not the right path. People right now are very confused. They really don't know what to do. They don't have really a strategy in place because they don't know how to acquire foreign products and likewise. Um, and most of the portfolios of all companies had at least between 18 to 20, sometimes 30% of interest in US or vice
Hmm.
versa, which is quite significant when you have production streamlined. So how all this is code up? I mean, right now it's not really that easy because you need to renegotiate with all your customers. Your customer might not be willing to do that, and you'll try to find a backdoor around to streamline the same product from somewhere else, but which is very, 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 very compelling and drastic, let's just say, because it's not easy at all with current law regarding tariffs. Um,
Wouldn't be easy to do if you were the only company doing it, right? It would still be hard. But every single company now in the entire world is having the same discussions with their suppliers, with their manufacturers,
yeah.
with their freight operators. So that is making it even harder. Like everybody is in the same boat
Yeah,
now in that nobody knows what to do.
yeah,
So for the companies I work with, again, like it was just easier. They're not of such a scale that they can get any attention from their manufacturers, from the freight operators, from their vendors. So it's better for them just to say, okay, I'm going to stop. I'm going to freeze it, and I'm going to let these big companies sort this out, and then I'll deal with this in a few months when we see kind of how things change and how they shift.
I think, and this is really my opinion, of course, that many things can be done, but this is not it. I mean,
Mhm.
definitely, this is not a strategy. This is not something to think in even doing. And this is not helping people and businesses because right now, financial market, you can physically see it's stopping. It's slowing down dramatically, and you can actually see by even the stock market, all the stock market is slowing down. There's even reports from the last 100 days that this government was actually the worst ever in U.S. history. It's been published already.
That's
So
that has been reported, yes. And Q1 what did my husband tell me? We had a loss of productivity in Q1. So that was reported. So if we have a loss of productivity in Q2 in the United States, we will be technically in a recession. Um, I am not an economist, but obviously I'm an attorney and I have a science background. But it feels to me as a non-economist like somebody took a 1985 economic policy and put it in 2025. It
yeah,
just feels like this idea maybe would have worked when the world wasn't so flat. Maybe it would have been good when the world wasn't so flat, but we've reached a point where this just isn't going to work. It feels like it's just not going to work. Um, but again, as I told you, Julio, I hope I'm wrong. For everybody's benefit, I hope I'm
I
wrong, but it feels like
I
it's not going to work.
I mean, I don't think you're wrong. Honestly, again, it's my opinion. I have some expertise in economy and international market, and I can tell you're not wrong. And millions of people are not wrong. And the problem is they don't know how to do it because who has to make a decision and do it is not doing it. So I mean, what advice would I give to everyone out there? Well, firstly, start looking at your streamlines, start looking at how you can optimize your internal processes, and start looking at the possibilities with customers that you can trade in. and start negotiating with at least 90 to 120 days, regulation on the tariffs that you can absorb, some percentage of the tariff or go 50-50 or 60-40, and negotiate part of it to continue to make deal. I mean, you need to have, you seriously need to be a very good negotiator. That's one thing. And that's the strategy I advise to everyone, because otherwise the market will stop. Because if the customer is not buy and you cannot produce, there's nothing to sell, and that's not a situation not even to look at. So what I advise to, from, even doesn't matter how big you are, big, intermediate, or small, start looking at how you can optimize your streamline. Doesn't matter if it's logistics, it doesn't matter from whatever part it is. Looking at that first, then start to putting that what you streamline to go up with your percentages to see how you can negotiate with the customer to absorb some of the percentage of the tariff and propose to the customer to absorb some other percentage of that tariff too. So this way you still be competitive. Of course the customer will pay a bit of higher price because he has to absorb some of the tariff, but that's I think it's the best solution to go up right now as it is, and negotiate that every 90 days as situation is. You know what's going to happen tomorrow, right? So don't do it for years. Do that every 90 days. We review it, something like that. And at least that's the advice I'm giving to everyone. Doesn't matter where you are, because right now, as the situation is and how things are, I don't see any other possibility of doing the other way around. Because if we don't do that, it becomes to a point that some manufacturers will no longer be able to produce some of the products. They will not be out. So the intermediate person, which is logistics, will be stopped because they have nothing to distribute. And the customer will run out of products, whatever they have in inventory. And when the inventory runs out, they need to, what they're going to do, So let's try to avoid that situation and not go back to 1920s or 1930s when it was the Big Depression.
Yeah, let's not go back there.
Yeah, let's not go back there, please. And this is my advice to everyone, or whoever it is in government. Please really review what you're doing and auto-evaluate. It's very important. Even the decisions coming from whoever it is, they need to be evaluated from many people, not just one or two or three, and see if it works in your actual market, because you need to evaluate will it work. What am I doing? I mean, it's like as I say, no, let's change now. The tariffs between how the system is regulated and how it's transported. No, man, you cannot do that. You need to see whatever strategy you're doing to see will it work in our current market. How is it working? And I think this gap would not think of. That's my opinion, anyway. So, what advice would you give right now to your customers that are facing this type of situation from your point of view?
So, I have and would tell them that they should talk to an attorney that specializes in import-export, international trade, because those clients that have talked to those specialized attorneys or counsel or specialists have come up with plans and strategies that are consistent with what other industries are doing to resolve some of these issues, coming up with ideas to propose to their manufacturers. It was 6 months ago, it was pretty standard for a Chinese manufacturer to split the tariffs 50-50.
Yeah.
What I have heard from clients is that with this new wave of tariffs, their manufacturers have been refusing to split them. But what I have been hearing is that there's also a lot of other discussion about other ways that they could limit the tariff exposure and still continue to manufacture and import and export. And specialized counsel is going to be really important in those discussions. The other thing I would tell them that I've had clients do with some success, which was a surprise to me, but I am told was very fruitful, is they've picked up the phone and they've called their competitors. And they've basically said, what are you doing?
Yeah.
Let's do the same thing. If we're gonna do some creative strategies to try to continue to stay in business with these tariffs, what are you doing? Let's do the same thing. Because at least in the United States, you could see where your exposure is going to be less if everybody did it.
Yeah.
Right? If you used a creative solution and you're kind of the only one out there using the creative solution, there's a little bit more risk that the government's going to take issue with your creative solution. But at least if everybody's doing it, you have some argument that, like, you thought it was okay, everybody was doing this, and so some of my clients have had really productive communications with their competitors, CEO to CEO, about how they could continue to operate in this climate. And so those are two things that I would recommend any company to do.
Right. So, Tamany, it's been almost 1 hour. Amazing conversation. You really was very insightful. I really learned myself also regarding IPO. So thank you for your knowledge and all your insights that you brought us today. So tell us how does people get in touch with you with IP Law?
Sure. You can go to my website. It's www.caiplaw.com.
Okay.
You can find me on TikTok at Tamany Bentz. If you're at all interested in IP law, I do informative TikToks on things going on in popular media and how IP law really affects them. And you can find me on Instagram at California IP Law, or actually Tamany Bentz at both.
Perfect. Wonderful. So before we finish, I always ask my guests to say a power message. What will be your power message today?
I'm going to circle us back to earlier in the episode, and I'm going to say, if you don't get thrown out on first base sometimes, you're not leading off the bag far enough.
Wonderful. So, Tamany, thank you so much for your time today. I really enjoy it. I'm pretty sure many people will enjoy, all the information that we share today. Very insightful and also very knowledgeable. So, thank you so much for joining us today, and all the best to you and all your future. Thank you.
Thank you so much, Julio.
Thank you.